Alright, hi. I couldn't find the public law for this, but I have the bill. This is the House of Representatives 3609, 107th Congress of the United States, the second session, and Act Section 1, short title amendment of the Title 49 United States Code. Um, Short title. The Act may be cited as the Pipeline Safety Improvement Act of 2002, amended the Title 49 United States Code, except for the otherwise expressed provided wherein the Act is amended with the repeal is expressed in terms of the amendment to the repeal section. Other provision references shall be considered made with the section other provision of the Title 49 United States Code. Alright, Section 2, on-call notification programs, minimum standard 6103 is amended in subsection A of the paragraph 1 by inserting all of the government operators before a semicolon at the end, and the operator inserting all of the government contractor excavators before the semicolon at the end of the subsection C. The striking provided with the inserting provided with the end for the end document. Compliance with the minimum standard 6104 D that's amended by striking with 3 years after the day of the enactment of the chapter secretary shall begin to and inserting the secretary shall implementing the best practices guideline in section 6105 amended to read as follows. Alright, 6105 implementation best practice guidelines. Adoption of the best practice Secretary of Transportation shall incur for the sake of the operators on-call notification program, excavators including government contractor excavators, underground facility operators adopt and implement and identify with the best practice report identified entitled Common Ground is periodic updated. Technical Assistance Secretary shall provide the technology assistance to participate in programs sponsored by nonprofit organizations specifically established for the purpose of reducing construction related damage to the underground facilities. Grants in general, the Secretary may grant to the nonprofit organization described in subsection B authorization operations in addition to the amounts authorized under section 6107 if it is authorized to be appropriated with the bank making grants under subsection 5 of $500,000 for each fiscal year 2003 to 2006. Such sums shall remain available until expended. General revenue funding and its sums are appropriated for the under subsection shall be derived, but the general revenues may not be derived for the amounts collected under 6301. Conforming amendment is the analysis chapter with the 60 amended with the striking item relating to 6105 inserting the following. Our authorization appropriation for grants of the state 6107 is amended with the striking $1 million fiscal year 2000 and shall, with the beginning of the period, end of the first sentence, inserting $1 million each fiscal year 2003 through 2006. From administration section 6107 B is amended by the for striking fiscal year 1990, 2000, 2001, starting fiscal year 2003 through 2006. Or section 3 on-call notification pipeline operators. Limitation preemption 6104C is amended by the adding of the following notwithstanding proceeding sentence state of authority may enforce requirements of on-call and one-call notification program state of the program meets the requirements of on-call notification program under the chapter 61. Minimum requirement 6114A2 is amended by the inserting and including of the government employee contractor personnel criminal penalty 6123 is amended in the matter proceeding paragraph 1 by striking the knowingly willfully paragraph 1 inserting knowingly willfully before engages. Striking paragraph 2B, inserting the following pipeline facility knows has a reason to know that the damage does not report the damage properly operated with the pipeline facility to the operator. Other appropriate authorities and or penalties under the subsection may be reduced in the case of the violation promptly reported by the violator. Or section 4, state oversight rule. State agreements with the certification 6106 is amended the subsection by striking general authority, inserting agreements with certification by designating B, C, and D, subsection C, D, and E, respectively, inserting after subsection A following agreements with the certification. And General Secretary except the certification 6105, making a determination required with the subsection Secretary may make an agreement with the state authority authorizing to participate with the oversight of the interstate pipeline transfer. Each such agreement include with the plan of the state authority to participate with a special investigation involving the incident of new construction, allows state authority to participate in other activities to oversight and overseeing interstate pipeline transportation, in addition to the inspection and investigatory duties. Nothing in the subsection to modify 6104C. Authorized Secretary to delegate the enforcement safety standard of the interstate pipeline facility described under Chapter State authority. Termination required. Secretary may not enter in an agreement under subsection N unless the Secretary determines in writing that an agreement allowed for the participation of state authority consistent with the Secretary program inspection, consistent with safety policies, providing under the chapter interstate participation agreement that would not adversely oversight of the responsibility of interstate pipeline transportation by state authorities. State is carrying out program demonstrated that promote the preparedness risk prevention activities that enable communities live safely within the pipelines and the state line within the state meets the minimum standard statewide notification set forth in Chapter 61, and the actions planned with under the agreement 9 and P, the interstate commerce or jeopardize public safety. Existing agreements for the request of the state authority secretary shall authorize the state authority which had an interstate agreement in effect of January 31st, 1999 to oversee the interstate pipeline transport pursuant to the terms of the agreement. The secretary determines state meets the requirements of paragraph 2 execute the new agreement until December 31st, 2003, which is sooner. Nothing in the paragraph shall prevent the secretary affording state notice hearing an opportunity to correct the alleged deficiencies, terminating the agreement with the effect before an enactment of Pipeline Safety Improvement Act of 2002. Or the state authority fails to comply with the terms and other agreements, the implementation agreement has resulted in the gap of the oversight responsibility interstate pipeline transportation of the state authority or continued participation by state authority in oversight of the interstate pipeline transportation had adversely impacted the pipeline safety. Ending agreement subsection E of the section 6E106 as is redesignated A2 of the section is amended. This reads as follows. Ending agreements permissive termination. Secretary may end the agreement under this section. Secretary finds that the state authority has not complied with the provision of the agreement, the mandatory termination of the agreement. Secretary shall end the agreement over the oversight of the interstate of the pipeline transportation. Secretary find that the implementation of such agreement has resulted in gap of oversight of the responsibility interstate pipeline transportation by state authority. State actions under the agreement have failed to meet the requirements of subsection B. Continued participation of state authority and oversight per interstate pipeline transportation will promote pipeline safety. Procedural requirements. And Secretary shall give the notice of the opportunity hearing the state authority before ending the agreement under section. Secretary provide the state opportunity to correct any of the deficiencies before ending the agreement. Defining the decision end of the agreement shall be published in Federal Register, may not become effective at least 15 days after the day of the publication. Secretary find the continuation of an agreement pros of the hazard. Secretary responds to state notice violation subsection C6106 redesignated subsection A2 of the section is amended by striking in each agreement and inserting the following in general of each agreement and adding the end of the following. Response of the Secretary of State Authority notifies the Secretary under paragraph 1 violation probable violation applicable to standards. Secretary not later than 60 days of the day of the receiving notification shall issue an order under 6118 to take the appropriate enforcement actions and ensure compliance with the chapter, provide state authority with a written explanation why the Secretary has determined not to take such action, and align with the text paragraph 1 and designated within subsection paragraph 2 is added in subsection. Public education program 6116 is amended as read as follows. In general, each owner and operator of the gas have the liquid pipeline safety shall carry out the continuing program to educate the public on the use of the on-call notification system prior to excavation damage prevention activities of the possible hazard association unintended release of the pipeline facility. Physical indication that such release may have occurred in the steps that should be taken to public safety in the event of the pipeline releases how to report such an event. Modification of existing programs no later than 12 months after the date of the enactment Pipeline Safety Improvement Act of 2002. Each owner and operator of the gas heads or liquid pipeline facility shall review the existing public education program for effectiveness, modify the program necessary for the completed program shall include the activities of the affected municipalities, school district, businesses, residents, pipeline facility locations. The completed program shall be submitted to the Secretary in the case of the interstate pipeline facility operator, appropriate state agency, and shall be periodically reviewed by the Secretary in case of the interstate pipeline facility operator, appropriate state agency. Standard Secretary may issue the standard for prescribing elements for the effect of the public education program. Secretary may also develop material for the use of in this program. Alright, Section 6, Protection Employees Providing Pipeline Safety. In general, 6001 is amended by adding the following. 60-129 Protection Employees Providing Pipeline Safety Improvement Act. Discrimination against employee. In general, no employer shall may discharge any employee otherwise discriminating against any employee with the respect for the compensated with the term of the condition, privileges, employment, to of the employee, any of the person acting with the pursuit of the request of the employee, provided with the call for the provided is about the provide call for the provide with the employer or federal government information relating to any violation, alleged violation, order, any order of the regulations stated under this chapter, or any other federal law relating to the pipeline safety refused to engage with the participate made unlawful the chapter of the other federal law relating public safety and privity identified with the eligibility of the employer. Alright, provide call to provide isn't about the provide the call to provide testimony before the Congress, federal, state, the provide proceeding regarding the provision for the chapter of any other federal law relating to pipeline safety. Commence and call for the commence is in about the commence for the call for the commence proceeding under the chapter of any other federal law relating to pipeline safety proceed with the administrator enforcing any of the requirement imposed under this chapter of any other federal law relating to pipeline safety, provided cause to be provided is about to provide and call for the to provide testimony in proceeding described in subparagraph D. F assisted with the participated in is about to assist with the in any of the manner such proceeding or in any other manner in proceeding any other action to carry out the purpose of the chapter any other federal law relating to pipeline safety. Employers defined in this section term employer means a person owning, operating pipeline facility, contractor, subcontractor, such person, Department of Labor complaint procedure, filing and notification person who believe he or she the discharged or otherwise discriminated against any of the person violation subsection may not be no later than 180 days of the such violation occurs filed with any of the person files on behalf of the, or his or her behalf of them the complaint with the Secretary of Labor alleging discharge relating labor shall notify them the writing of the person's unnamed in the complaint with the Secretary of Transportation file a complaint with the alleged allegations and the complaint shall have substance of the evidence supporting the complaint of the end of the opportunity shall be afforded with the such person or persons on paragraph 2 investigation preliminary order. In general, no later than 60 days after the due receipt of the complaint filed under paragraph 1 after the forwarding the person of the person named in person or persons named in the complaint, an opportunity to submit to the Secretary of Labor written response to the complaint with an opportunity to meet with the representative of the Secretary of Labor representative of the statement of witness. Secretary of Labor shall conduct the investigation determine whether the reasonable cause to believe the complaint has merit notified written complaint with the person alleged to have committed the violation subsection A and Secretary of Labor finding Secretary of Labor and conclude that there is reasonable cause to believe the violation subsection has occurred with the Secretary of Labor shall include Secretary of Labor finding with the preliminary order providing the least prescribed in paragraph 3 and B notwithstanding 60 days of the day of the notification finding under subparagraph any person alleged to have committed the violation complaint that may be filed with the objection finding with the preliminary or both or the request of the hearing on record filing in such objection if it is not appropriate to state with the reinstatement of the remedy with the continued contained with the preliminary such hearings shall be conducted expeditiously. If hearings is not requested such 60-day period with the preliminary order shall deem the final order not subject to additional review. Her requirements required showing by the complaint that the Secretary of Labor shall dismiss the complaint filed with the subsection shall not be conducted investigating otherwise required in subparagraph A unless the complaint makes a prima facie showing any behavior described in subsection A was contributing factor of the unreasonable favor personnel action alleged in complaint and showing by the employer notwithstanding the final finding of the Secretary of Labor complaint that has been made showing required in subclause 1 no investigation required in the subparagraph A shall be conducted with the employer demonstrated the clear and convincing evidence that the employer would have taken the same unfavorable personnel action in the absence of the behavior. Criteria of the determination Secretary of Labor described the violation of the subsection has occurred only if the complaint demonstrated that any of the behavior that described in subsection A of the contributing factor in the unfavorable personal action alleged in the complaint. Prohibition relief may be ordered with the under subparagraph A of the employer demonstrated the clear and convincing evidence that the employer will have taken the same unfavorable personal action in the absence of the behavior. Final order. Deadline of the issuing settlement agreement no later than 9 days of the day of the conclusion of hearing the paragraph 2 of the Secretary of Labor shall issue the final order and provide with the relief prescribed in the paragraph denying the complaint at any of the time before issuing the final order proceeding under this subsection may be terminated on the basis of settlement agreement entered in the Secretary of Labor. The complaint and the person are alleged to have committed the violation. Remedy the response to the complaint filed under paragraph 1 Secretary of Labor to determine the violation in subsection A has occurred. The Secretary of Labor should order person or persons committed in such violation take an affirmative action to abate the violation, reinstate the complaint with his or her former position together with compensate, including back pay, and restore the term of the conditions and privileges associated with his or her employment, provided the compensatory damage of the complaint. Such order issued on paragraph Secretary of Labor to request the complaint shall assess against person or persons against whom that order is issued within some of the equal to the aggregated amount with all costs expensive, including attorney, expert, witness fees, reasonable and incurable determined by the Secretary of Labor the complaint with the four in connection with the bringing of the complaint upon the order was issued. Frivolous complaint with the Secretary of Labor finding the complaints on paragraph 1 of frivolous have been brought with the favor of the Secretary of Labor may award the prevailing employer reasonable attorney the fee not exceeding $1,000. Review appeal to the court. Appeals any person adversely affected by the degree of the end by order issued on paragraph 3 of the exam of the review of the order of the United States with respect to the order issued and alleged or occurred with the circle with the claim with the reside of the violation of the issue review must be filed no later than 60 days of the day the issue filed order of the Secretary of Labor review shall conform with Chapter 7 of the Title 5 United States Code. Commencement of proceeding under paragraph subparagraph shall not unless ordered by court operative of the state of the order limitation collateral action of the Secretary of will respect with the review that could have the same subparagraph A, but there shall not be just judicial review and criminal other civil proceeding. Enforcement or order Secretary of Labor with any of the person failed to comply with the order issued on paragraph 3 with the Secretary of Labor may file with the civil action in the United States District Court with the district in violation was found to occur with the enforcement such order and actions brought under this paragraph, the district court shall jurisdiction grant all appropriate relief, including but not limited to injunction relief and compensatory damages. All right, enforcement by of order by parties, commencement of action pursuant to the belief may have of the order issued. Paragraph 3 may commence a civil action against the person or persons to such order issued by the regular compliance with such order. The appropriate United States District Court shall have jurisdiction without regard for the amount of the controversy of citizenship of the parties and enforce such order. Return fee of the court issuing any of the final order in paragraphs may reward costs of litigation, including reasonable attorney, expert, witness fees, and any of the whenever the court determines such award costs as appropriate. Mandamus is an non-discretionary duty imposed with the section enforceability mandamus proceeding under section 1361 Title 48 United States Code. Non-applicability to deliberate violation subsection A shall not be applied with respect to the actuation of the employer acting without the direction of the employer. Such a employer's agent deliberately covered the violation of any of the requirements relating to pipeline safety under this chapter or any other law under the United States. Civil Penalty 6122A is amended, adding the end of the following personal violation 6129 or any order issued liable to the government. Civil penalty are not more than $1,000 each. Violation penalty provided in paragraph do not apply with the violation 6129 an order issued thereafter. Conforming the amendment analyzing chapter 601 is amending ending of the following. Alright, section 7 safety order 6117 is amended ending of the following. The safety order secretary decides that the pipeline facility with a potential safely related condition, secretary may order the operator to facilitate necessary corrective action, including physical inspection, testing, repair, replacement, other appropriate application remedy, safety related conditions. Section 8 penalties. Pipeline facility has for life and property of the environment. General Authority 6112A with the demand of the region follows. General Authority after the notice opportunity of the hearing, the Secretary of Transportation may decide if the pipeline hazard facility hazard if the Secretary decides the operation of the facility is or would have been hazard for life of the property environment. The facility would be constructed operative of the component of the facility would be constructed operative of the equipment material the technique of the Secretary decide the hazard for life and property environment. Corrective action order section 6112D is amendment the striking hazard inserting if is or would be hazards enforcement. Civil penalty 6122A is amendment in striking $25,000 inserting $100,000 and B by striking $500,000 inserting $1 million. Penalty consideration 6122B with the adding of the striking under the section allowed with the file with the paragraph 4 with the inserting under the section. Secretary shall consider nature, circumstance of the gravity of violation, including the adverse impact of the environment with respect to the violator, degree of the culpability and history of the prior violation, the ability to pay, and effect of the ability to continue with the doing business, and with good faith is attempting to comply with the Secretary may consider the economic benefit of the gain of the violation without reductions. We cover the subsequent damages, other proper matters, and justice requires. Civil action 6120A is amended to striking A civil actions in one and all the following of the two at the request inserting the following civil actions. Civil actions 2 and 4 of the chapter of the request of the Secretary of Transportation, Attorney General, that may be the civil action appropriate district court of the United States in 4th chapter, including the section 6112 of the regulation prescribed in order issued under the chapter. Court may award the appropriate relief for the end by the temporary permanent jurisdiction injunction punitive damage for the assessment of civil penalties. Consider the same factor prescribed in the Secretary is in administrative case 6122. Civil action require compliance with the subpoenas allowed with the inspection at the request of the alignment of the remainder of the text paragraph 1. Civil penalties damaging facility 6123 is amended by striking other gas pipeline facility, inserting after liquid pipeline facility following either interstate gas pipeline facility, interstate has a liquid pipeline that is used in the interstate foreign commerce or the activity affecting the interstate of the foreign commerce. The Comptroller General study. The Comptroller General shall conduct the study of the action policy of the end pursuit of the Secretary of Transportation, such as collecting fine for the penalty the operator has liquid gas transmission pipelines. Analysts conducting the study of the Comptroller shall examine the minimum fine with the frequency of which the Secretary has the substitute the corrective order of the fine penalty, the change of the amount of the fine recommended safety inspectors of the Secretary, actual collectivity evaluation, overall effectiveness of the Secretary enforcement strategy, to the extent that the Secretary has complied with the report of the government accounting officers entitled with the pipeline safety, the office of the pipeline safety changing have the oversee of the pipeline industry, and reporting no later than the first year after the date of the enactment of the act of the Comptroller General transfer the Committee of the Science of the Transportation Committee of the Committee of the Transportation Infrastructure for the Energy of the Commerce to the House of Representatives the report of the result of the study. Alright, Section 9 Pipeline Safety Information Grants of the Communities in General 601 is further amended by adding the following Pipeline Safety Information Grants Committee of the Grant Authority and Secretary of Transportation may grant with the technical assistance local communities group of individuals, not including not-for-profit entities, relating to the safety pipeline facility of the local communities of the facility regulated within public law 93-153, Title 43, United States Code 6051, 10 sequence. Secretary shall establish the procedure for the awarding grants under section with the criteria for the selecting grant recipient's amount with the name of the grant owner section not exceeding $50,000. Single grant recipient, the secretary shall establish appropriate procedures to ensure the proper use of the funding under this section. Technical assistance defined in subsection term. The technical assistance mean engineering, other scientific analysis, pipeline safety issues, including the promotion of the public participation, official proceedings, conducted under this chapter. Prohibited use funds provided under this section may not be used for lobbying, direct support, litigation. Annual report in general no later than 90 days after the last of each of the official year with the grants or made with the secretary under the section. Secretary shall report with the committee for the Commerce, Science, and Transportation and Energy, Natural Resources of the Committee for the Transportation, Infrastructure, and Energy Comments for the House of Representatives on the grants made under the section preceding official year. Content of the report shall include a listing of the identity, location of each of the recipient grant under the section preceding the official year, amount of the received by the recipient, a description of the purpose of which each grant was made, and a description of how to each grant was used by the recipient. D. Authorization of the appropriations authorized by the appropriate with the Secretary of Transportation carrying off the section $1 million for each of the fiscal year 2003 through 2006. Or such amendments should not be derived of the user fees collected under 6301, conforming an amendment to the analysis of Chapter 601 is amended adding its investigation in the following. Section 10, Operator Assistance Investigator. In General 6118 is amended that adding the following: the Operator Assistance Investigation Secretary of the National Transportation Safety Board investigation of accidental involved with the pipeline facility operator facility to make available to the Secretary Board all records and information any way pertaining to the accident, including the integrity management plan. Such results shall afford all reasonable assistance for the investigation of the accident. Corrective action order 6112D is amended, instructing this if the Secretary inserting the following in general, if the Secretary adding the following: the actions attributable to an employee, if the corrective action the order to issue following the accident, and the Secretary determine the action of the employee carrying out an activity regulated with the chapter include the duties of the section 6102A may be contributed to substantial to cover the action the cause of the accident. Secretary shall direct the operator to relieve the employee from performing those activities, assigning the employee and placing the employee on a leave until the earlier date on which Secretary, after notice of the opportunity hearing, determine the employee actions did not contribute substantial to cause the accident. Secretary determine the employee has been requalified, retrained, provided by the section 6131. It can be safely performed those activities. Effective collective bargaining agreements and action taken with the operator under paragraph 2 shall be in accordance with the terms and conditions applicable to the collective bargaining agreement, but aligning the remainder of the text of paragraph 1 described in paragraph 1 subsection paragraph 2 as that in paragraph 2 the subsection limitation statutory construction 6118 is amended, ending the following: limitation statutory construction. Nothing in this section may be construed and infringe upon the constitutional rights of an operator or its employees. 6011 the population encroachment right of ways in general. 6127 is amended to read as follows: 6127 the population encroachment right as follows: right of ways the Secretary of Transportation in conjunction with the Federal Energy Regulatory Commission and consultation appropriate to federal agency and state and local governments shall undertake study of the land using participating in ordinance preservation of the environmental resource with regard to the pipeline right away to the maintenance. Purpose of the study shall provide to gather information land of the practices of ordinance preservation, environmental resource, determine the effective of the practice of the limiting encroachment existing pipeline right away to prevent has risk of the public and pipeline worker the involvement associated with the encroachment pipeline right away. Raise the awareness of the risk it has for the encroachment pipeline right away, and address and how to preserve the environmental resource in conjunction maintain pipeline right away, recognizing pipeline operator regulatory object obligations to the maintain right away to protect the public safety. Consideration conducting study of the Secretary shall consider the minimum following: 1. The legal authority of federal agency and state with the local government's control of the land use of limitations of such authorities. The current practice of the federal agency, state, and local governments of addressing land use issuing involved with the pipeline. 7. The most effective way with the encourage federal agency, state, local governments to monitoring and reduce encroachment upon pipeline right of ways. Report in general with no later than 1 year after the enactment of the subsection. Secretary shall publish report identify the practical law ordinance that are most likely successful addressing issuing encroachment and maintenance of the pipeline right away as to more effectively protect public safety, pipeline workers, and the environmental distribution of the right. Report: the Secretary should provide a copy of the report Congress approved with the federal agency state of the further distribution of the appropriate local authorities adoption of practice laws and ordinance. Secretary should encourage federal agency state of local governments to adopt and implement appropriate practice law of the ordinance identified in the report with the address of the risk and have it associated with encroachment of the pipeline right away to address potential method of preserving environmental resources with the maintaining pipeline right away with consistent with the pipeline safety. Conforming amendment the analysis of the Chapter 601 is amendment the striking the time item relating to 6127 inserting the following. Our Section 12 pipeline integrity, safety, reliability, research, and development, and the head of the participating agency carrying over the program research, demonstration, and standardization to ensure integrity of the pipeline facility. In general, no later than 120 days after the dividend act, the exit of the head of the participating agency shall enter for the memorandum of the understanding of the detail of the respective responsibility of the program authorized by subsection A. Areas of expertise on everything in the memorandum is the understanding each of the participating agency shall have the primary responsibility for issuing the elements of the program of the expertise limit limited in accordance with this section. The Department of Transportation responsibility shall reflect its lead role of the pipeline safety experience with the pipeline inspection, integrity management, damage prevention. The Department of Energy responsibility should reflect with the expertise and system reliability, low volume gas leak detection, surveillance techniques. National Institute Standard Technology responsible shall reflect expertise, materials for research, assisting developing and consensus technical standards in the term is used in Section 12D4, Public Law 104.13, Title 15, Title 15, United States Code 272. No. Program elements. Program authorized the subsection A shall include the research, demonstration, and standards activities related to material inspection, structural, fractional, and analysis, detection, cracks, corrosion, abrasion, other abnormalities inside of the pipe that lead to pipeline failure, to develop new equipment, or technology that insert pipeline detecting anomalies. Internal inspection, leak detection is technology included detection leaks of the very low volumes, method of the analyzing content of the pipeline security, including the proving the real-time surveillance pipeline right away, the developing tools, evaluation, enhancing pipeline security infrastructure relating to reducing natural technological terrorist threats and protecting first responders to units personnel near incident risk assessment methodology, including vulnerability assessment, reduction, third-party damage. 7. Communication control and information system security and fire safety pipelines, improved excavation, construction, repair technologies, other appropriate elements. Program plan, general within the first year after the date enactment. The section Secretary of Transportation coordinated with the Secretary of Energy and the Director of the National Institute of Standard Technology shall prepare with the transmit the Congress 5-year program plan for the guide with the activity units. Section program plan shall be with the technical pipeline safety standard of the committee with the technical head for liquid pipeline safety standard of the committee for review of the report of the Congress, include the comments of the committees. The 5-year program plan with the memorandum of understanding with the under subsection B taking account with related activity for federal agencies. Constellation and preparing program plan with the selecting prioritizing appropriate project proposal of the Secretary of Transportation consult with and secretly advise the appropriate representative of the natural gas, crude oil, the petroleum product pipeline industries, the utilities, manufacturing, inspection, higher learning, federal agency, pipeline research institution, national laboratory, state pipeline, state officials, laboratory organization, environmental organization, pipeline safety advocates, professional and technical societies. Report to Congress no later than 1 year after the date of the enactment of this act, and thereafter any of the head of the participating and agency shall submit the joint with the Congress report to have the result of the date of the implementation of the program prepared under subsection D. Authorization appropriations, Department of the Transportation, the authorized appropriate of the Secretary of Transportation carrying out with $10 million each fiscal year of the 2003 through 2006. Department of Energy, the authorized appropriate of the Secretary of Energy carrying out with the section 1 million for the each of the fiscal year 2003 through 2006. National Institute, the Chain of the Technology authorized to be appropriate of the Director of the National Institute Standards Technology carrying out $5 million each fiscal year 2003 through 2006. General revenue finding that any sum of the appropriate of the subsection derived of the general revenues may not be derived under the amounts collected under Section 6301, Title 49 United States Code. Pipeline Integrity Program on the amounts available to the Oil Spill Liability Trust established and set by Section 9509 General Revenue Code of 1986. $3 million shall be transferred to the Secretary of Transportation as provided appropriate action. Carry out all programs of detection, prevention, mitigation of oil spills for each of the fiscal year 2003 to 2006. Participation agencies defined in section participating agencies been the Department of Transportation, Department of Energy, National Institute of Standard Technology. And Section 13 pipeline qualification programs. We're going to cut the tape there.